Welcome to Tracing Your Family Roots. My name is Arlene Sachs, and today our guest is Lindsay Tanziger. Welcome. I'm so glad you're here with us. And Lindsay's with Covington and Burling, and she's a copyright lawyer, and that's what we're going to be talking about, how copyright refers to genealogy. And what is copyright law, and why should a genealogist be concerned about it?
Yeah, it's a good question. Thank you for having me, first of all. And I just want to mention, everything we're talking about today is just background. I'm not giving any legal advice. But copyright is actually the ability to control or prevent somebody else from using or copying your work. And it actually stems from the U.S. Constitution. There's a provision in there that says, you have the exclusive rights for a limited time. And then the Congress has gone through and fleshed out what that means. And genealogists should care about it because they want to be able to copyright their own works, and they also want to be careful because when they're using other people's works in their own family histories, they can really open themselves up to copyright infringement lawsuits if they're not careful about the way in which, making sure that they gain permission and using the works appropriately.
There's actually another area in which has come up that I'm familiar with. Genealogists also produce research manuals and things and references. And so when you're producing reference works and research works, you're assembling things that exist out in out there in the public, and the question of what you can use and when comes up a lot.
Yeah,
not
exactly.
just with your own history.
Well, how do I know if something's copyrighted? If I find something, and whether it's on the web or whatever.
A lot of times it'll tell you. It'll have the copyright notice, and it'll tell you the year that it was published and who the author is. Unfortunately, a lot of times it doesn't. There used to be that you'd have to put that notice on there, and you'd have to register the work with the Copyright Office in order for it to be protected. But that's not true today. So even if it doesn't have the notice, it's still potentially copyrighted. So you have to be careful about what you use and what you don't use.
Well, Lindsay, was there once a time when you had just 3 months or something like that to file your copyright, or else you lost it?
There were times, yes, exactly. The 3 months is a little short, but you had to, depending on the year, you would have a limited amount of time before you'd have to go to the Copyright Office.
So then my question is, if something was produced in the past before the rule, today there's a rule that you don't have to file.
Exactly.
Once there was a rule that you had to file? Once upon a time you...
Yeah.
Okay, what if the item of interest that you're concerned about was produced back when there was a rule that you had to file, and that person didn't file? Was it protected retrospectively?
Unfortunately, it gets very complicated. So anything that was published prior to 1923 is now in the public domain, and you can freely use it. And then in the 1970s, everything that was published after the about the mid-1970s, the current copyright law applies. But in that time period in between, there's actually all sorts of complications, because if they didn't register it in time, they could potentially have lost the copyright. Others, if they, there's other laws that have gone back and allowed them to take certain measures so that they could regain the copyright in it. So you really have to look at, you have to figure out what date it was published in order to figure out how long it's copyrightable, and if it's how long it's been copyrighted, and whether or not it's even copyrighted in the first place.
So roughly the 50 years from like 1923 to 1973, there might be...
There's all sorts of complexities.
Okay.
What's the difference then, like if you were writing a paper, or where you have a lot of footnotes, and the footnote might say this is from this and this book, and how is that different from getting a copyright permission? Or is it? Well, of course, sometimes you're referring to very old books which wouldn't be copyrighted anymore.
Yeah, exactly. If it's before 1923, it's in the public domain, and you freely use it. But a lot of times, if within the book scenario, you can flip to the title page or the page right after it or before it, and it'll tell you, who the publisher is and what year it was published and everything. And
copyrights last how long?
It actually is another complication because it depends. If it's assuming the current law applies, if it's a known individual, it's the author's life plus 70 years. If it was written by a corporation, though, it's actually 95 years from publication. So
what if it's neither a single author nor a corporation, but 3 authors?
Yeah, there is the provision in the Copyright Act that deals with joint authors, and then it's going to look jointly at the lifespans plus the 70 years of authorship from the last living person. So.
Okay. All right.
So that as long as the person's alive, they have the copyright?
Mm-hmm.
Oh.
Right,
Yeah.
but the book that our local genealogy society holds the copyright to, that Russian consular record book that we did. We're not a corporation, I guess, or are we? We're a 501c3. I guess we are a corporation.
It would fall.
Yeah, it depends. It's hard to talk about specific facts. There's all sorts of.
Well, what about if I want to use a photograph or other materials from my family history? It's a picture my sister took or my grandfather took or something like that.
And it's copyrighted?
Well, I don't know. How would you know? I mean,
If you don't have to file for a copyright,
how would you know?
would every photograph you take be copyrighted?
As long as it's original and fixed in a tangible medium of expression, it's copyrightable. And as long as it's a certain, photographs are copyrightable, stories are copyrightable. There are some things that are not copyrightable, like government works that the government has produced, or titles and slogans, things like that. But as long as it falls within the categories of things that can be copyrighted, it's copyrighted once it's original and fixed in a tangible form.
So then any photographs I've taken are copyrighted?
As long as they're original, yeah.
So if my sister sent me a picture of the family gathering and I just used it, she could potentially sue me because it was her picture.
Yeah, you'd hope that she'd give you permission, which is really what it comes down to. Whenever you're working with a copyrighted material, you want to make sure that you have permission to use it before you go ahead and use it.
But would you have to write by every picture, copyright or permission of so and so, let's say in a book with lots of pictures? You have to indicate that you've got permission for every single one of them?
It's not, the indication of the permission is not necessarily what's critical. What's important is that you actually have gone to the author and sought their permission. And a lot of times you really want to get that permission in writing, just in case 5 years down the road they come back and say, hey, I didn't give you permission. This way you can say, yes, you did. I have it in writing right here.
But you don't have to say so in the. For example, in my journal we print talks that people have given, and they haven't actually appeared in print, but they're now on a DVD, on a cassette someplace, and they've sent me the typescript, or I've listened and transcribed it, and they say yes, you can use it, and so I print it, but I don't have to say this is reproduced with permission.
Well, that's not required by the copyright law. A lot of times it's the right thing to do, or people will request that you do that as part of them allowing you to use the materials.
Well, you do, because you still put the author's name on it.
Right.
So it's not like you're trying to put your own name on it or anything.
It also is good practice, just because then when somebody else wants to use that picture, they know who to go to if they themselves want to seek permission.
It's very true, because that's the chasing down of the person who holds the copyright can be enormously hard.
What if you can't find the author?
Yeah, like I said, you generally want to get permission, but there are provisions in the Copyright Act that are kind of a safety valve to allow people to use copyrighted works in certain scenarios. And the largest safety valve is the Fair Use Doctrine.
What's that?
The Fair Use Doctrine is a provision in the copyright law that allows people to use things for things like news reporting and news gathering, and it's a 4-factor test that the courts will look at.
Okay.
They'll look at the nature and characteristic of the copyrighted or the use. So a lot of times that comes down to, is it commercial or is it non-commercial? They'll look at as well. They'll look at the nature of the copyrighted work. So, for example, is it a really expressive work like a movie or sound recording, or is it a factual work like a list of data? The third factor that they look at is the amount and substantiality of the work that's used. So are you using all but one page of the work, or are you just using a small portion? And a lot of times they'll look at whether or not the portion that you do use is the heart of the work. Is it really that critical piece of the work that is really where all the value's at? And then finally they'll look at whether or not your use has a damaging impact on the market for that work. So they'll look at all of those factors, and unfortunately there's no bright line test for when you're acting in fair use and when the fair use defense doesn't apply. But they'll weigh those factors, and if they can find that it's actually a fair use, then you can go ahead and use it even if you don't have permission.
I can see where it gets very complicated.
Oh, and where you can really be in trouble, because if potentially each case, what I'm getting from what you're saying is that each case is decided itself on its own.
It's very much dependent on the facts of the case.
So there's no way to be 100% sure in advance that you're okay if you haven't gotten track down the missing person.
Yeah.
Sometimes somebody could come later and say,
well, if you kept track, let's say you couldn't find somebody, if you wrote down for yourself or kept track of all of the people that you tried to contact in order to find the author, does that protect you at all?
It doesn't guarantee protection, but in a lot of these cases, it's all going to come down to whether or not you acted in good faith. Did you really make an effort? Did you do your best? It's when you're sitting down and copying word for word and it's clear, you're just trying to appropriate their value from their work and make it your own. That's where there's going to be problems. So you always just want to try to make sure you're doing the right thing, and that's going to go a long ways.
Yeah, it comes up in many situations. As a psychologist giving IQ tests, there's a form that you use, that you record the answers on. The form is copyrighted. Well, I know school systems that just run off Xeroxes of that form and say, oh, that's okay because we're school systems and we're a nonprofit, and well, that means you didn't buy the forms. The forms are sold. Yeah,
it becomes very difficult. There are actually some provisions in the Copyright Act that apply specifically to schools, so they have a little bit more leeway sometimes, but you still have to be very careful about what you're doing to make sure you're not running afoul of the provisions.
And it boils down to sort of the commercial value. From what I'm hearing, everything funnels into this is something that has commercial value, and are you doing something to destroy that commercial value or to diminish the commercial value?
Yeah, that's definitely a big chunk of it. And of course, it doesn't have to be commercial value. Copyright Act actually doesn't look at the artistic or aesthetic merit of the work in order for it to be copyrighted. And even if it's something that will never make money, it can still be copyrighted. But yeah, whenever money comes into play, that's where you're going to have more risks of litigation, or people are going to start to ask questions because they want to protect that value.
Mm-hmm. Let's shift a little bit. We've been talking about printed material. What about the websites and everything that you find on the internet now?
It's a great question. That's where a lot of the law right now is being developed, just because there's so many questions about when is something published online? When is it fixed online? And how do I find the author? There's jurisdictional questions because the author might be in Germany and you're here in the United States. But in general, the law applies to the internet just like it does to anything else. So just because it's posted online doesn't mean that you can use it. It's still potentially copyrighted.
Whose law? U.S. law, German law, Russian law? Whose law?
And that's always a very difficult question, just because there's very complex choice of law provisions that courts will look at to figure out whose law applies.
So the law in the United States is your lifetime plus 70 years. Is that the law all over the world?
Not necessarily. There have been measures to try to standardize the intellectual property laws as much as possible, but even when every country has its own interests and has, like for example, in Europe there's actually a big input on moral rights of the author, making sure that the work is considered kind of like to be a part of the author. So when you manipulate the work or destroy the work, it's kind of seen as a harm or damage to that author. And in the U.S., that has not been the case historically. So there's been a big push to try to figure out, well, what do we do with this moral rights question? Should the United States honor that? And they've taken some measures to try to do that, but they haven't gone as far.
Can you give an example of something where the moral, where you said if the person what are you talking about? Give me an example of something.
Yeah, I paint a painting. I've painted the next Mona Lisa. Somebody wants to come around and draw a mustache on my Mona Lisa. In Europe, in some places, that's not okay. That could be damaging to my reputation. Where in the United States, and we have implemented some measures that protect certain types of paintings if they're limited reproductions, but it's not the same protection that you would find elsewhere.
Oh, that's interesting.
That is very.
So let's say somebody here wrote something and somebody in Europe picked it up and used it without permission. It's pretty hard for anybody here to go copying, getting something over there. Could they go get a German lawyer to sue him in the German courts?
Yeah, and again, there's all sorts of international treaties, like the Berne Convention is actually one that really makes it easier for rights owners or copyright owners to enforce their rights in other countries. But again, a lot of it's going to, they're just practically speaking, how are you going to find out who that person even is, especially on the internet where people use anonymous screen names and hide their IP addresses.
Well, I mean, suppose you knew because they published it. Mm-hmm. They actually published it in a book. Then you could find a lawyer in Germany.
Except in real life, it's so expensive to do it that when they stole an article from my journal and published it in a book in Germany, the guy said, tough luck, Yeah, you're right, I did take it. Go do something about it.
Yeah, unfortunately, any time the law is at issue, a lot of times the expense is a factor that you have to consider.
Right, exactly.
You want to ask the last one?
Oh, the article that I publish a genealogy journal.
Well, you remember you're going to keep it general.
Well, we're keeping it general. Okay, we publish a journal. Authors write articles for it. We don't pay for the articles. Mm-hmm. And sometimes people want to put a copyright notice on their article, whereupon we say, gee, we won't use the article because the magazine is copyrighted. If we want to make an anthology or whatever, we want to be free to do that. Mm-hmm. So what we've taken to doing is to say to authors, you may always use your article in other places, but we want the right to use it also as it was published in Avotino. Please, if you're going to use it subsequent to the publication, just put this first appeared in mm-hmm. such and such and such and such. Is that any kind of problem that you can see?
Well, just speaking generally, because I don't know all the facts of the situation that you talk about, but once a copyright owner has the rights to control the use and distribution and so forth of their works, and in licensing others to use those works, they can put all sorts of conditions on that use. They can say, yeah, you have to give me credit, even though the copyright law doesn't require that. So you see that a lot happening in the marketplace. That's very common, actually.
Where you do that sort of, we don't
negotiating back and forth, yeah.
So as long as the author knows he can use it anytime he wants, and you can use it anytime you want.
As it's been played out, is there much litigation in the area of copyright? Is it something that comes up a lot?
Oh yeah, definitely.
What kinds of issues would be examples of that?
A lot of things are going. A lot of the lawsuits right now are actually dealing with the website issues. You see a lot of websites that are, where people post video to them, and there's questions about, well, who is the owner of that video? What happens if somebody else comes and uses that video? Who do they have to pay to use it, or do they pay the person who originally uploaded it? Do they pay the website owner? There's questions about fair use. What is fair use online? So I'd say that's where the litigation is really being brought.
And if somebody takes this show and puts it on a website somewhere, that would be a violation. Even if we have not applied for a copyright, is it assumed that this TV show that we're making now is copyrighted?
Yeah, you definitely do not have to register for your copyright. Registration does, however, have some benefits. You can get certain statutory damages, and people can't claim that they're an innocent infringer. So registering your works is always a good thing. But like you said, it's definitely not required. Of course, there would have to be questions about whether or not they had some defense to use it. Did they use it within the confines of fair use, or did they have some other right to use it?
What would be fair use? I mean, if it was another genealogy website that, say, picked it up.
Well, it really, like I said, depends on the facts of the circumstance and circumstances.
Other than fair use, what other kinds of defenses would you have for infringing?
A lot of them are very fact specific. So, like I mentioned before, schools have certain rights. Libraries have there's certain provisions dealing with libraries. But another common one is the for sale defense, which says, I might have this book and I might have copyright in the book itself, but once I sell it to you, I can't prevent you from selling it on to Arlene. So it allows you to continue transferring copyrighted works, even though you hold the copyright in the material. But you can't put limitations on the distribution of the tangible item.
And if something appeared in print before 1923 and it's sitting on a library shelf, and I say, oh, this is out of print, I think I'll reissue this book in total. There's nothing to prevent that, right?
As long as it was, if it's before 1923, it's not so much it's out of print that matters, but it's the year, the 1923. And I actually brought a couple examples. There's a couple pictures that were published prior to 1923 that I got off a government website. And yeah, so these are kind of examples of things that you could use, and you wouldn't be implicating the Copyright Act problem.
And the other question is, none of the materials produced by the U.S. government is copyrighted. Is that correct?
Right. Government works are not copyrighted. What you have to be careful of, though, is a lot of times if you go to a government website, just because it's on their website doesn't mean that they've published it. A lot of times they'll actually get content from third parties, and if they put it on their website, that doesn't mean that the copyright goes away. So you'll have to look to see, is it say copyright U.S. government, or does it say copyright somebody else?
So if you took like pictures from old newspapers and any of that stuff, that all if you're nice, you put it say sources of the Library of Congress or something like a photo courtesy of the Library of Congress.
And that's,
but for old pictures and stuff.
Yeah, that's a good point, because a lot of the websites do ask that you give, that you say that you got it from whatever the government source is, and there can be some contract issues that arise separate and apart from the copyright law questions.
Now, you had that one picture. Did you have more than that? Was that family picture, or was that the other picture?
Yeah, they were both examples of fair use, because they were both they're both in the public domain now, because they're prior to 1923.
But if you took the photograph and put it in a book that you've written, and you've copyrighted the book, that photograph still is not covered by copyright.
Right.
Other people can use the book.
They could go to the Library of Congress to get
and
it,
get it elsewhere.
Exactly. You can't pull things out of the public domain once they're in there. But if you take say you take 100 pictures and you selected these 100 pictures from thousands of pictures and you've arranged them and you've annotated them, you can get copyright in the new work, your new contribution. It doesn't mean you have copyright to the picture itself, but you have copyright in the way that you've arranged
it. If they
them.
copy the page that shows the arrangement and the captions, that is copyrighted.
As long as it's original and fixed. Yep.
It's very confusing.
It does. It does. It's but I don't know. It doesn't. Have you heard of any genealogists who've said you can't use that because it's mine and it's copyrighted?
I really haven't. I think genealogists in general are more willing to share it because they want to find out what the other person has too. Although there's a case where somebody took my genealogy, which I had sent to someone else, and she forwarded to another very, very distant cousin, and he put the whole thing on the web.
Yeah.
And or gave it to
That's right.
And there's all of my information sitting. I know it had to come from me because it's the way I addressed my grandmother, and nobody other than my sister would have used that term. And there it's sitting there, and it aggravates me. But there's nothing I can do because he's given it to another web page to.
It's tricky, especially on the internet. Once it's out there, it's kind of out there. It's hard to get it back.
But has he violated her copyright? She gave him a copy.
No, I gave it to somebody else who gave it to him.
Okay,
and she says too she was annoyed by this because she didn't know he was going to publish it.
But here's
either.
my thing: once you gave your family tree to somebody else, you still held the copyright to it, even though you've given it to them. A copy of it to them, yeah.
Yeah. I mean, it's I don't know all the facts, so it's tricky to say one way or the other. But I think that would be an example of the first sale doctrine. Once you still have copyright in the work, the material, but you couldn't prevent your sister from distributing it to somebody else
and putting it on the web.
If that person, did something with your content, that you could potentially be liable.
I had sent it to this person because we were trying to establish, like we were 6th or 7th cousins or something like that, and that's where we. And this person also was, way far back. And
way at the beginning of the internet, somebody took some material out of a book that I have the copyright to and just put it on the web, and was very worked up and indignant when I said, "Please remove it."
Yeah.
Yeah.
It's hard to know how to handle it because, if you're a genealogist, you're not making any money from what you've done, and how can you go and sue somebody? If they're then taking it and publishing it and making money from it, and you're not getting any of it.
Oh yeah, there's also we get more than copyright. We get privacy issues.
Yeah.
The Privacy Act.
No, that's
and which is different in Europe, and that's a whole. That's sometimes people try to use copyright as a way to fight the other.
Oh yeah, and vice versa. Yeah, definitely.
Yes, as a way of controlling. But in practical terms, for one person to sue another person for copyright infringement is probably pretty costly.
Yeah, I mean, of course it depends. A lot of times you try to work these things out in negotiations beforehand, so you don't actually have to get to trial. But yeah.
Exactly. So people can get away with it a fair amount.
Yeah, it's hard to tell, you know, but it is an issue.
Yes, of course.
Yeah, I think genealogists sort of want credit for the work that they've done rather than being, I mean, some of them are interested in money. I mean, obviously the person that's picked it up from you wants to do it for money.
You know what's interesting to me? Where in the Constitution is it? I didn't know it was in the Constitution.
Yeah, it's Article 1, Section 8, Clause 8.
Really?
Yeah,
Article 1 is a Bill of Rights articles,
No, Bill of Rights is separate.
Okay.
But it says, it grants Congress the power to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Now that's one sentence. Then you get the Copyright Act, which is, you know, a volume, and it, really just fleshes it out in much more detail.
It's interesting that they thought of something like that far back, and I mean, how we take the very basics that they wrote and interpret them. Thank you so much for being on the show.
Thank you for having me.
We've got about 30 seconds left. Is
the devil's in the details.
Yeah, exactly.
Well, thank you very much, and this has been very informative, very interesting.
Thank you so much. Thank you.